I feel vindicated.
A state election law case 10 years in the making.
This is never about us. We, for better or worse, jumped in front of a moving train, but we did it on our own.
In 2014, State Senator Rob Sampson was running for re-election in the House, and now former state lawmaker Joe Markley was seeking re-election in the Senate. Both candidates used campaign materials which named and criticized then Governor Dannel Malloy's tax and fiscal policies. Sampson and Markley were receiving public money for their campaigns through the state's Citizens Election Program. One of the rules of using money from the voluntary Citizens Election Program is a candidate cannot spend their public funds campaigning for others not in their race. Sampson's Democratic opponent in 2014 filed a complaint saying Sampson and Markley violated that rule by mentioning Malloy and his policies. The State Elections Enforcement Commission agreed, and in 2018 fined the two lawmakers a combined $7,000, saying they essentially used their public funds on the 2014 governor's race, campaigning for Malloy's opponent.
Political speech has been stifled ever since the original case began.
Sampson and Markley fought the commission's decision, going to Superior Court in 2022 and eventually appealing to the state Supreme Court. Monday, the Connecticut Supreme Court ruled unanimously in Sampson and Markley's favor. In their decision, the justices wrote, none of the communications at issue in this appeal could reasonably be construed as anything more than a rhetorical device intended to communicate the merits of the plaintiff's candidacies as bulwarks against the policies endorsed by Governor Malloy and the Democratic Party.
I understand the desire to have, some sort of rules and regulations to govern how campaigns are run and financed. That makes sense. But when that system grows to a point where they're actually affecting the ability of candidates to be able to choose what their speech is, then they've crossed the line.
This decision now holds ramifications for the 2024 election cycle.
In 2014, Dan Malloy was unpopular, and Democrats were concerned that Republicans would tie their Democratic opponents to Dan Malloy. In 2024, Donald Trump in Connecticut is pretty unpopular, and I think now Democrats will try to tie their Republican opponents to Donald Trump. The question isn't who it benefits. The question is what's fair, what's constitutional. Sometimes it's going to help one side, sometimes it's going to help the other side. That's a sign that it's a fair thing.
And I did reach out to the State Elections Enforcement Commission. In a statement, their executive director and general counsel, Mike Brandy, said, we are currently reviewing the decision and will consult with our commission and the Attorney General's office to determine the path forward. Brandy added, we respect the court's decision and will work to provide appropriate guidance to the regulated community. Brent, Bridget.